Justice Adeyemi Ajayi of the High Court of the Federal Capital Territory has ordered that a former Accountant General of the Federation, Ahmed Idris, and 2 other co-defendants be remanded in prison pending hearing on their application for bail in a case of alleged fraud in the sum of 109 billion preferred against them. The judge had refused an application for Mr. Idris and the 2 other defendants to continue with the administrative bail earlier granted by them anti-graft agency. The judge had refused an application for Mr. Idris and the 2 other defendants to continue with the administrative bail earlier granted them by the anti-graft agency, the Economic and Financial Crime Commission (EFCC). Counsel to the former Accountant General Chris Uchesan had prayed the court to allow his client go home and return to court on the resumption of the trial, with counsel to the other defendants equally praying same.
There is nothing abnormal. In fact, for me, what is interesting in this is that plea has been taken and the charges have been read. And interestingly, what are contained in the charges are quite different from what was dished out to the media. Because in the media, it has been all over the place that the man collected billions of naira from the treasury. But what we have seen shows that the contents of the book are quite different from the title of the book itself. What we now saw read are charges that funds for the from the 13% derivation handled by the Federation Accounts Allocation Committee, that a consultant handled the thing, and then that some gratification was given, which is yet to be proved and which we don't admit to. So it's not even a case of any funds missing from the government treasury. So this is what is very instructive to me as far as this matter is concerned. Then, normally when charges are read like this, applications for bail will be filed. Simply because the matter was arraigned today, the application was filed and served today. So technically it might not be possible for the application to be heard and granted. Therefore it was adjourned. Then, as to the request, whether they should be remanded in prison custody or the EFCC custody, well, it's up to the discretion of the court, and the court did exercise its discretion in the way it dealt fit. So we don't have any problem with that, and we're also very happy that the adjournment is not a long one, it's quite a reasonable one. So we come back on Wednesday and hear this matter on its merit, because I'm as equally curious and anxious as every other member of the society. I want to see the details of this matter, and from the bit I have seen in the proof of evidence is a far cry from the humongous figures, fantastic sums that are being bundled. You can see that this whole charge is being used to suppress and cover something else. And I'm very confident that this trial will expose that thing that is trying to be suppressed.
But counsel to the prosecution, Rotimi Jacob, opposed the application of the defendants, insisting that the validity of their administrative bail had elapsed since the charges had been filed. In her ruling, the judge therefore maintained that the court does not dance to the applause of public opinion, insisting it acts on the provisions of law. She added that with the defendants having filed their formal application for bail, a date needs to be scheduled for hearing on this, and she fixed Wednesday, 27 July, for hearing on the bail application. Mr. Idris was arraigned alongside Godfrey Olusegun Akindele, Mohammed Kudu Usman, and Gazawa Commodity Market and Exchange Limited on the 14th count charge, bordering on stealing and criminal branch of trust.
When you see the charge, you will see what was in the media before. It's the same amount, it's the same figure, and you see the confessional statement there. It's only in our country that somebody who make a confessional statement will still come before the world and tell the world that he's innocent. So it has to tell you about our value system. Get the confessional statement made by all of them. These some were admitted by them. So it's not a question of being played to the gallery or saying something different. It is a exact figure that you people reported that is in the charge, and they themselves in their own handwriting, in the presence of their own lawyer, admitted it. I'm surprised that somebody can come here and say that EFCC was doing a media trial. I didn't want to grab this interview because of that. That's why I have to come here and debunk that. It is not true. It is not so. So I think we should have conscience and let our conscience direct our actions. So it is not that is totally untrue.
Then I said, with the confessionals may be part of the evidence.
It's already before the court. It's already before the court. A statement you made before your lawyer, the lawyer who was before the granting interview, they have their own representation. When these people were making statements that they collected the money, that they were Accountant General, and that the other second defendant was also working under him in the office of Accountant General, and they got the contract, and then without doing any work, and you collected that kind of money, and then you are saying with the figure branded in the media is not the same figure they were charged. It's really unfortunate. When you want to know what happens in the hair, you need somebody there to come and testify. So, because we want to know the theory of the case, we want to know what happened in the hair, then we need a witness in that hair to come and testify.
Ojoni Samson, GTV Africa.